autonomy. And sovereignty would mean right to acquire new areas and right to cede new areas, right to acquire territory and right to cede territories, which we have in Article 1, 2, 3, 4. Constitution of India has. Lord, none of the attributes of a constitution, so to say, Lord, can be attached to this constitution. It was a piece of legislature recognized, accepted, and known till 5th of August and 6th of August 2019 as constitution. But for all intent and purposes, my lord, it was, my lord, even the preamble of the constitution doesn't say so. A preamble of constitution of Jammu and Kashmir doesn't say so, that this is a document which is a constitution. It merely says, Lord, please see the preamble of Jammu and Kashmir constitution. It says, with a view to further define our relationship with Union of India. It doesn't say that we are creating a constitution of our governance. So please see, that's the only purpose. They say, we the people of Jammu and Kashmir, with a view to, I'll just read for your lordship, my lord. Lord, I'll just read, my lord. It is, kindly note the page. Volume 2, page 16. Your lordship need not open. I'll just read. Even preamble doesn't say that it has attributes of a constitution per se. We, the people of the state of Jammu and Kashmir.
Mr. Solicitor, there is another more fundamental reason why your argument may be correct, which is this. Look at Section 5 of the J&K Constitution. It says the executive and legislative power of the state extends to all matters except those with respect to which Parliament has the power to make laws for the state under the provisions of the Constitution of India. So once the Constitution of India defines which is the area in respect of which Parliament has the power to make laws, then that is denuded from the jurisdiction of the Jammu and Kashmir Legislative Assembly. Now we have seen how progressively the ambit of the legislative domain of Parliament was expanded. For instance, initially the entire concurrent list was outside the power of Parliament.
Correct.
You had only certain entries in list 1, the union list.
I am obliging.
Right? Subsequently, the concurrent list was brought in. Once the concurrent list is brought in within the domain of Parliament, to that extent, the legislative domain of the Jammu and Kashmir Legislative Assembly is denuded. Then entry 97 was wholly outside the purview of Parliament initially. Later on, as we see, entry 97 is also gradually brought in within the purview of Parliament, albeit in the context of laws affecting the sovereignty and integrity of India, terrorism, so on and so forth. Therefore, it's very obvious from Section 5 of the J&K Constitution that once the Constitution of India prescribes a certain legislative domain for Parliament, then that is progressively denuded from the legislative ambit of the J&K Legislative Assembly. And that was not fixed as of 1957. Another very important feature is that Section 5 does not fix the ambit of the legislative or executive domain of the J&K government and the Legislative Assembly as of 26th of January 1957.
Correct.
In fact, it contemplates that what the Constitution of India will prescribe for Parliament will be outside the domain of the
of our domain.
In that sense, it is always intended to be subservient to the Constitution of India.
And my lord,
it's not really a document which has equivalent effect.
And that's what the 147 makes these provisions unamendable. Section 147. 3 and 5 cannot be amended. Otherwise, what happens? Lord, this is amendable. This constitution, if it would have survived, was amendable by the Legislative Assembly. So, they can amend their preamble and academically, potentially, can become a theocratic state because secularism was not applicable.
All right, Mr. Solicitor, I think we've gone through your Article 370 note. Now, what your Constituent Assembly note? Now, what's about?
Now, my lord,
now you have to deal with the important part about states reorganization and the conversion of the state into a UT. How do you answer that?
Lord, I'll take a little time on this one, not unrealistic time, but there are 3-4 judgments, my lord, which are direct judgments.
All right.
So your lordships would bear in mind the difference between our constitution and say Constitution of America, where there is a contract between the state and the federal government, and that is how they form the United States. The federal government doesn't have the power to even alter the boundaries of the states because it's a different and distinct.
There's no contract between the states and the federal government in the US.
Internal.
The 13 colonies came together to form a union, and they surrendered some powers to the union.
To the union, otherwise retaining, my lord, some of the states have its own Supreme Court, etc. My lord, whenever, my lord, a nation like ours and the federalism which we have accepted, which is, my lord, kind of leaning towards unitary feature. I'm not arguing on that unitary versus federalism. But at times, the nation requires to rejudge the boundaries and the status of their states. So there are several considerations. And therefore, at the outset, my lord, I may point out that this is a case, one of its type, which is not to be encountered, my lord, by the court. For example, if Gujarat was to be bifurcated or Madhya Pradesh was to be bifurcated, the parameters would be different. But when Jammu and Kashmir, considering its very strategic importance, border state, history of terrorism, history of infiltrations, history of outside influence, outside means outside the country, etc., there would be several considerations in the mind of the government. We share border with 4 at least countries, all of which may not be friendly, to put it mildly. That's what I say.
Argument based on border states is a problem. We have many states on the border.
No, history also. The history, I have given the details in my affidavit, filed long back, how the situation in Kashmir is developing. The number of deaths of civilians, the number of deaths of security forces, the number of attacks, the number of stone pelting, the number of every week 2 or 3 days of hartal, paralyzing schools, hospitals, banks, business houses, everything. All these are policy considerations. Whenever a state reorganization takes place, not only there are policy considerations as to why the state needs to be reorganized, but there is always a blueprint as to what the central government would do after the state is reorganized. How to bring, in a peculiar facts of this case, the youth in the mainstream, how to ensure that they are gainfully employed, how to float certain schemes so that people on the bordering or who are continuous facing the attacks of shelling, etc., are now getting a sense of confidence that the government has not left us, etc. There are several considerations that we will have to start with, say, democratic local self-government elections so that the people participate in the internal local self-government institutions for their own good.
The source of the power to reorganize, which is with the Union of India, is the same.
3 and 4.
Right.
Parameters would differ.
But therefore, do you concede that power to the Union in respect of every Indian state? You're not saying that you should concede that, no, this only exists for J&K, it exists for every Indian state, right?
The power is for all.
Once you concede that power to the Union in relation to every Indian state, how do you ensure that, the kind of abuse that they apprehended, we are now not defining it for today, but what we lay down would be the law for the last. It is revised by some larger bench at some point of time. But how do you ensure then that this power will not be
used, in case of others? That was my worry. I share your lordship's worry, and therefore, I started by saying that your lordships are dealing with a one of its kind situation, which is not going to arise, my lord. And if, my lord,
But it's
I
not-
point out, my lord,
it's
after
not one of its kind situation. We have seen on the northern border, Punjab, very difficult times. Similarly, some states at different times in northeast, all border states.
One of the states in northeast presently.
Presently, many
None of
times
them.
as because of whatever reasons near the border, we can't choose our neighbors, as they often say. We have had problems.
correct.
So the worry which Chief Justice expresses is that tomorrow, if there is a scenario of order, can each of these states face this problem?
And why each of these states only, my lord? It can happen to, my lord, for example, Madhya Pradesh or Gujarat or any state.
Your argument from the borders is what I'm testing. See, there are states which are on border of other countries where situation may not be very palatable. Now, at least those border states, I understood your argument that these border states are category by themselves. How do we distinguish between Jammu and Kashmir and any other border state?
I'll just, my lord, I'm
This is
grateful.
what is
I'll point out. My lord, none of the border states, take, my lord, northeastern states or Punjab, as your lordships gave an example.
Uttarakhand has a border state.
Northeastern states or Punjab or any other. Rajasthan has a border, Gujarat has a border.
What possibly is being pointed out, you can't say because it's a border state, so it has to be treated.
I'm not saying it, my lord, that's not the distinction I'm drawing.
Because then it's a very, it'll be.
My lord, there are several border states, Gujarat, Rajasthan,
Himachal, Uttarakhand.
Uttarakhand, Himachal. I'm not, my lord, kindly don't misunderstand my submission that because it is a border state, it requires different treatment. My lord, kindly see the consistent, repeated situation which we are facing since decades on a daily basis is not happening in Gujarat or Northeast or any other border state. Here is a border state where one of our territory is occupied by Pakistan, or we have POK. I have given figures. My lord, what are the deaths taking place every year, right from 20 years before? This is a problem faced by the nation from decades, since decades, which we are, my lord, trying to, my lord, sort out or deal with. And I'll show, my lord, this is not, my lord, just, these decisions are never taken as knee-jerk reactions. There is always, my lord, policy considerations. Border state, this particular state being a different kind of a border state is one, but there are several considerations. And one of the consideration would be how to bring the youth in the mainstream. And I'll point out, my lord, everything was kept in mind and is implemented. And what we are seeing today is the result of that blueprint being implemented. My lord, after this my lord, decision, there were elections which took place of district development councils. There are 34,000 elected people. Democracy going to the grassroots. There are, Lord, large number of schemes which are introduced. Lord, the youth which used to be employed by the interest not inimical to India, my lord, maybe terror groups or whoever, and were paid, now are gainfully employed. My lord, there is always a blueprint, and I'll be able to show that blueprint working. My lord, I'm not conscious of the fact that end would not justify the means, but end, your lordships can certainly see whether these policy considerations which decided the reorganization were correct or not. Because the government has acted with a blueprint, not only for reorganization, what would be done after reorganization and how Jammu and Kashmir would return to normalcy. And I'll be able to show the steps which are taken. Right now, my lord, I will deal with in three parts. My lord, the impression which is given to your lordship is that this has been reduced from state to union territory. Means there is a downgradation. And my lord, there are some other factually incorrect statements were made, my lord, by one of the council, my lord, who argued for reorganization, against reorganization, that we lost this, there is no representation, there is no consolidated fund of India, we can't participate in election of president, our seats in the parliament is
So
gone.
let's look at it at the first level, basic level, the textual level of the constitution. Let's go step by step. Then we'll go to the last part, namely, which was what motivated this decision. And there you have said that these are policy considerations. Look at the nature of the state, the history. You can't lose sight of all that. We must also deal with it at a textual level. Does Parliament have the power to convert an existing Indian state into a union territory?
Yes.
If it does have that power, how do you read Article 3? If you can just assist us on, that's the
Before
basic
that,
textual question.
Lord, yes, Lord, there are, my lord, specific judicial pronouncements on that.
No, but we will go to the judicial pronouncements.
I'll
But why don't you
actually,
first look at the text of the statute?
Before that,
of the Constitution.
may I request your lordships to have a just bird's eye view of the Reorganization Act itself? No one has shown that, my lord, to your lordships. I want your lordships to see that.
You look at the Reorganization Act, that will provide us.
I'm not reading every part. I'm just taking your lordships through the titles. Lord, nobody has read, my lord, and
First, that's worrying us. Let's look at the source of the power.
kindly come to, my lord, Article 3.
Just in a minute or so.
Yes,
Just how you interpret
Article 3. Article 3.
Also, I would like to know whether it's some kind of what is the nature of exercise of that power? Is it a permanent exercise of power? Is it a temporary exercise of power? What is
No,
that?
it is, my lord, I must, Lord, let me answer that straight. Lord, this question was put in the parliament when the reorganization bill was passed. Lord, I'll just read, my lord, the statement of the honorable minister on the floor of the house.
So the union territory here is not intended to be a permanent territory.
No, my lord.
All right.
And that's what, my lord, I'm making.
Question number two.
Yes.
Number two. How impermanent is it? And question number three, when are we going to have elections?
I understand, my lord. So that is why, my lord, I was going to show to your lordships the steps taken to ensure that we reach that stage. I will show those steps, my lord.
All right. Now let's go to Article 3.
Article 3. Article 3, formation of new states and alteration of areas, boundaries, or names of existing states. Lord, first, my lord, before that, please read, my lord, explanation 1 so that your lordships can read in that context. In this article, in clause A to E, state includes a union territory, but in the proviso, state does not include a union territory. Correct, my lords?
So wherever you read state, read union territory.
Union
That's what.
territory except the proviso.
So now let's read clause
yes,
A
yes.
in the light of that.
Yes, ma'am. And, my lord, this very reorganization has been subjected, and, my lord, this honorable court has said that it is permissible. This reorganization act has passed the muster of your lordships under 3 and 4. The judgment I'll show. Parliament may by law form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. So, my lord, I would read, Parliament may by law form a new union territory by separation of territory from any state or by uniting two or more states, we are not concerned, or parts of the state, again, we are not concerned. So there is a power of having two union territories out of one state, then B, increase the area of any state, diminish the area of any state, alter the boundaries of any state. But here, this would also result.
Does clause A contemplate a situation when the entirety of a state can become a union territory?
There are two, Jammu and Kashmir and Ladakh. And there is nothing, my lord, which
Does
prohibits.
clause A contemplate a situation where an entirety of a state can become, say, more than one union territory? What you have done?
It can, my lord. I'm not answering that question because that doesn't arise here.
Your argument is that because of explanation, we will have to read union territory.
Yes.
In clause one.
And in a given case, my lord, I don't want to pitch that high.
See, clause A, the problem. Form a new union territory, we will not read it as state. Form a new union territory, singular will include a plural. So form more than one union territory, no problem. Form a new union territory by doing what?
By separation of territory from any state. Territory means geographical area.
Right. So from the state of J&K, you carve out a territory and form, say, a union territory of Ladakh.
Jammu, Kashmir and Ladakh. But I don't want to, my lord, pitch that high. But otherwise, it would not prohibit even a state being made union territory. But that's not the question we are dealing with, my lord.
So the first part of clause A, in other words, according to you, form a new union territory by separation of territory from any state.
And
Would
singular.
contemplate a situation where you have a larger state and you contemplate the creation of a union territory by separating out a territory. In this case, you separated out a territory to form the union territory of Ladakh, and then the remaining you carved out and said this will be the union territory of.
It will not amount to reading. Suppose you had not carved out Ladakh and you had declared the whole thing as a UT.
Lord, there is no restriction in doing that. I don't wish to pitch it that high.
I'm going to test and understand. Suppose you create one UT only. Then it is form a new state by separation of territory from any state. That has not occurred. No UT has been carved out. Or by uniting two or more states or part of the state, or by uniting any of the territory into part of the state. How will it apply? Suppose you had not carved out Ladakh.
Possibly,
whole
possibly.
State, so then the power would be the conversion of any state into a UT.
That possibly
The
is
fact that you carve out a part of a state,
possibly, your lordships are right. That is not
higher.
that is possibly not contemplated, subject to. But form a new state, that is form a new union territory.
That's the proposition.
By separation of territory from any state. So separation is necessary.
So if you don't separate and create, you really, how do you contemplate converting a state into UT? And if, I'm just saying for the sake of argument, if that is not possible, can you do that by carving out a UT and making the other also UT?
There is no restrictions. And this is how, my lord, it is understood by your lordships also. Because, for example, my lord, Assam, Tripura, and Arunachal became UT first and thereafter became state. Assam remained a state, that's the distinction. But Assam could have also become a UT. There is no restriction.
That's what I'm saying. See, just carving out Ladakh as a UT is, I would say, less complicated in its nature. So therefore, to test the proposition, I'm saying, suppose you don't carve out UT, Ladakh. You decide that the whole state should be a UT. So can you do that and say J&K state will remain as it is as boundary, but from state it becomes a UT? When we want it, we'll reconvert it back to the state.
My lord, my first reading is separation is necessary. That's my first reading.
That is what is a little...
Because that question we are not faced, my lord, right now in this.
So the question will arise to test it that if you cannot convert a state into a UT, then can you carve out a UT? Is fine. But in the bargain also say that what I could not do without carving out a UT, I can do it now by making both of them the UT.
No, because I had a separate reason to carve out Ladakh as a separate UT.
You may. No difficulty. That's your decision. That's why I'm saying that's less complicated
Yes.
by its nature. Carving out a UT.
Here it's less complicated.
Reducing both parts of the carved out and the pre-carved out. So suppose Assam, you carved out a UT. But you say no, we carve out a portion of the Assam as UT, and also convert Assam into UT. That's the testing proposition.
It would be an extreme Lord, example, but for the purpose of testing, Lord, there can be two answers. A, separation would be necessary, and if separation takes place, Lord, that doesn't take place if one state is declared UT. So one state cannot be declared.
What is troubling you? Whether
Your Lordships are right, my Lord. One state possibly, my Lord, under 3 cannot be declared as UT. But here, it is nobody's case that we declared Ladakh as UT to come out of this embargo. It's nobody's case. We had separate reasons.
Mr. Solicitor, there may be another way of looking at it. Apropos the theme with which you began, which is the general situation in Jammu and Kashmir. As we see, the creation of union territories post-independence, you have on the one hand examples like Chandigarh, which was carved out during the Punjab Reorganization Act and remained a union territory. It is a permanent union territory.
It was a part of state.
It was a part of a state and became a union territory to be the common capital for 2 sister states. That's one. Then you have a progression where certain areas of existing states became union territories in the progression of making them states. That's the Northeast. For instance, you have Mizoram, you have Manipur, you have Tripura. They were part of states. They become union territories, but that's in the process of making them into a stable administration to become states. You can't immediately make them states. Parliament can certainly make that. Today, the situation is not right to make them full-fledged states. Today, we will carve them out, give them the status of a union territory. At a future point of time, when Parliament feels that, well, they now are sufficiently stable institutionally, we will make them as states, which we did in the Northeast. To put something, perhaps you may look at what we are trying to suggest. Why is it not possible for the union to say that, well, right now, say in a case of a particular state, we have such an extreme situation in terms of national security, in terms of, other...
We want direct control.
That we want for a certain stipulated period that a union territory should be created. But this creation of a union territory is not a feature of permanence. But this shall then again progress back to its position of a state.
Removing the reasons why it was required to be converted.
The union not have a control for a certain stipulated period to bring stability, because ultimately, let's face it, whether it's a state, whether it's a union territory, all of us have survived, the nation survives.
Yes.
Right?
Doubtlessly.
If the nation itself doesn't survive, there's no question, there's no relevance of states or union territories. So is it not necessary, should we not give that allowance to Parliament to sort of postulate that for a certain period, in the interest of the preservation of the nation itself, in the interest of the preservation of the union itself, we want for a certain stipulated period that this particular state should go into the fold of union territory on the clear understanding that this shall revert to a position of a state over a period of time. You can't lay down that period in a given case. In a given case, it may be 6 months. In a given case, it may be 1 year. But that progression, I think the government has to also make a statement before us.
Look,
that progression back to a state has to take place. It can't be a union territory in permanence.
I'm grateful, my lord. That's exactly, I'll read, my lord, after the lunch. That's exactly the statement made on the floor of the House. I'll read, my lord, that statement. That this is not a permanent feature. After the situation returns to normalcy, we want it to become a state again. I'll read, my lord, that statement.
And then after lunch, we would also have we don't want to bind you down to because we are conscious of the fact that these are matters of national security. We understand that, ultimately the preservation of the nation itself is the overriding concern. But without putting you in a sense of a bind, both you and attorney may seek instructions at the highest level. Is there some time frame in view?
Time frame. I'll take instructions once fallen from your lordships, but I'll show the statement made on the floor and the efforts made. And the statement is, once the efforts are fruitful and everything is normal, then, my lord, there is a. But I'll
equally, Mr. Solicitor and Mr. Attorney, restoration of democracy is a very important.
Absolutely.
It's a vital component for our nation.
In 2020,
we can't have a situation where you have
Lord, only one thing, Lord, give me a second more. In 2020, for the first time in the history, the local government elections took place. 34,000 people are now elected people, which is possible only because of.
Therefore, the progression, we take your point. We take your point that the progression has already begun.
Yes, Lord. No hartal, no stone pelting, no curfew.
That means situation is normal, Lord.
But
No, I am not only on Malod election and politics. I am on Malod national integrity.
is there a roadmap?
Yes, yes, it is.
And tell us what the
Yes.
roadmap is.